Hey everybody, welcome back to Thursday night. John Skiba here with the Consumer Warrior YouTube channel, doing what we do each and every Thursday night, with the exception of last week. I wasn't here. I was up at Lake Powell. If you're a follower of my channel for any amount of time, you know that that's where I vacation, is up at beautiful Lake Powell up on the Utah-Arizona border. But I'm back, somewhat rested and ready to go. So what we do each week here on the live stream is go over anything debt related. Again, for those of you new here, my name is John Skiba, founder of the Consumer Warrior YouTube channel. I do a live stream each and every Thursday, and it's really in connection with my law practice. I'm a licensed attorney in the state of Arizona. I do bankruptcy, defend people against debt collection, lawsuits, that kind of stuff. Whether it's debt related, garnishment, all that other kind of stuff, that's what I do. So each and every week, I like to do a live Q&A, just to give you some pointers and maybe point you in the right direction. I found the number one thing that alleviates a lot of stress related to debt is really understanding the process, understanding what your options are, and that there is a way to deal with these things. You know, a lot of people I always say they go to the worst place in their mind about what's going to happen. There is a way to deal with these things, and it's almost always not as bad as you're thinking it's going to be. My weekly disclaimer is, even though I'm a licensed attorney in Arizona, I'm not licensed anywhere else. This isn't legal advice. This is just some guy talking on YouTube. So take it for what it's worth. If you need actual legal advice when you're in the state of Arizona, my information is below. I'll actually throw a link in the chat section, and you can actually set up an appointment and you'll talk to me about what's going on in your situation. Put that in there. But if you're in another state and you need legal advice, I recommend you contact an attorney in that particular state. I'd also ask you to visit the website of our sponsor, Solo Suit. If you want to check them out, there's a link at the top of the chat section on YouTube and in the comment section on Facebook. That'll show you some of the products that they offer as it relates to helping people with debt settlement, responding to debt collection lawsuits, even compelling arbitration. Click on that link. There's some great products there, great tools to help you in your debt battle. It's a great way to deal with that and also to help sponsor the channel. So with that being said, gosh, we already have a bunch of questions in here. That's what happens when I miss a week. There's more things to go over. But Hercules is here once again. A lot of questions. See if we can get through these here. He says, I have a case against LVNV. LVNV is a junk debt buyer. They do a lot of buying of debt and suing people, with a pretrial hearing coming up that will also address their motion for summary disposition and my motions to extend discovery and to compel the forward flow agreement. I filed a motion to compel production of documents and a request for expedited ruling before the last day of the 30-day discovery period. I requested the forward flow agreement, but LVNV didn't provide it or explain why. The judge seemed inclined to rule in LVNV's favor based on the bill of sale and other documents they produced. And then he says, what strategy or strategies can help me avoid losing? You really got to frame what the forward flow agreement is. And let me even take a step back. You need to make sure, and you know, most judges are aware of this, but look, the purpose of discovery, if you look at the rules, it's usually rule 32, 33, 34 of the rules of civil procedure in your particular state. The purpose of discovery is not always to get admissible documents. It's not always to get information that for sure is going to be used in trial. It's discovery. So you can disguise somewhat of a fishing expedition. That's the whole point of it, is to try to get information, documents. That's not to say that they're always going to be used in court, but you're supposed to be given, each side is supposed to be given the opportunity to seek additional information, documentation. This document, you know, I don't know what they could, I know what objections they raise, but as far as they raise these objections saying that they shouldn't have to turn over the forward flow agreement, and they'll say something like relevance, you know, or they'll cite some kind of privilege. There is no privilege for this. There might be some information in there that the court will let them redact. But here's what I would do. This is the document. The forward flow agreement is the document between original creditor and junk debt buyer that gives the junk debt buyer standing to even be there. Without the forward flow agreement, sometimes it's called the master purchase and sale agreement, you'll see in the bill of sale. Without that document, they can't even be here. They can't be in court because they don't have standing. that, there's no what we call privity of contract between the parties. When I'm in court, I always say, look, this debt buyer didn't loan my client any money. My client didn't agree to pay them any money. So they have got to prove standing. They've got to show why it is that they should be able to sue you when there is no agreement between you and them to enter for the providing of payments, anything like that. So it's completely relevant. So they'll get up there and say that it's not necessary. It's not up to the creditor to determine what's necessary. This is discovery. If it in any way touches the case or could lead to additional discoverable information, and that's probably the key point. You're allowed to get anything that is related to the case or that could lead to additional discoverable information. They've got to provide it. And so you've got to be really kind of aggressive with this, because it drives me nuts when courts just kind of go along with the debt buyer just because, particularly people who are not represented by counsel, the consumer. Just because the creditor's attorney is saying that it's not necessary, who cares what they think about it? This is you. You have to put up your defense. You should be able to provide or get the discovery necessary to be able to put up your defense. So those are the kinds of things that I would recommend you do. Be persistent on it and see if you can get that squared away. All right. Carpe Diem says, a debt collector sued me in Virginia in 2023. And after one round of hearing, they filed for non-suit, which the judge accepted as a right. I recently received a debt validation letter from the same. How should I respond to this, and why did they seek to collect again? Okay, and so this procedure is a little different than we do it here in Arizona. But you're saying, so after a hearing, they filed for non-suit, which the judge accepted. Okay, and then you received the debt validation letter from the same, so they're coming after you again. So part of the issue is if the creditor, and this is very similar in Arizona, when a case is dismissed without prejudice. If a case is dismissed without prejudice, it means that it can be refiled again at any point, assuming that you're within the statute of limitations. So sounds like that's what happened here. They moved to have the case dismissed. It's dismissed without prejudice, and that means that they can refile it again. So that's likely what you're seeing here. And can they seek to collect again? They can if it's outside the statute, if it's still within the statute of limitations. Now, the time when the prior case was pending typically does not count, it is included within the statute of limitations. So if the case was pending for 4 or 5 months and then gets dismissed, those 4 or 5 months still count towards the overall statute of limitations. So you need to see exactly how long it's been in default, and if it's well within the statute of limitations at that point. So, all right. BSKA says, I got hit on my bicycle and the driver's insurance company is suing me for the car repair cost. Should I fight it? This is a good question and outside the realm of what I do. This kind of goes to a point I sometimes will bring up to people. In the old days, it used to be that it's kind of like general practitioners when it comes to doctors. If there's something seriously wrong, you're going to go to a specialist. With lawyers, it's very much that way now. It used to be if you see a lawyer and, their business card says they do wills and trust, divorce, bankruptcy, personal injury, run away from that. The law is way too specialized these days for an attorney to do all that. It's all I can do as a bankruptcy and debt collection practitioner to keep up with everything that's going on, the way that the law evolves. It's very difficult. So that's my long, drawn out way of saying BSKA. I wish I could give you some better information there, but it's something where you're going to need to talk to a personal injury attorney on that for sure to make sure that you know exactly what it is that needs to go on there. All right, here's some comments from the from my YouTube channel. It says this is in relation to a bankruptcy video where someone was saying, look, if I file bankruptcy, what am I going to do for these unexpected expenses? So if my credit card is wiped out, which it would be in a Chapter 7 bankruptcy, that would be eliminated. I can only live on cash on hand, ? What do I do for major repairs that I need to pay on time? @49 MacMan. All right. 49 MacMan. I mean, this is where if you follow like Dave Ramsey, his approach of having the emergency fund, he recommends $1,000. And frankly, that even he's saying that's kind of outdated because things are way more expensive now. But setting aside some savings in the event that something like that happens. So if there's major repairs for a vehicle, like my house, our dryer just broke, we had to have somebody come in and fix the dryer, that kind of thing. That's what you need to have that emergency fund set aside for. I will tell you this, something a lot of people are really surprised about. If you file Chapter 7 bankruptcy, within a week of filing, your mailbox is just getting full of credit card applications, car loan advertisements, all that in the mail. It's something where you will be able to get credit cards fairly quickly. You'll be able to get car loans pretty quickly. You're just going to have bad interest rates early on, and the limit is not going to be very high. My recommendation, if you're going through Chapter 7, you want to avoid credit cards as kind of a way like this to cover expenses that are out there. You don't want to have those where you're continuing to use those. Here's where I kind of Dave Ramsey-ish in that you need a credit card really in today's world. If you've ever tried to rent a car without one, I have. For a long time, my wife and I really tried to stick to the Dave Ramsey thing, no credit cards. And one time I got essentially trapped in a car rental place with my son. It was at 10 o'clock at night in the middle of Virginia in this small airport, and they weren't going to rent us a car. I had plenty of money in the debit card. They don't care. They weren't going to rent it to us. And it was just turning into a big whole debacle. It's after I told my wife, we just got to have a credit card, particularly if we're going to be traveling a lot. We got to have a credit card to get that squared away. All right. This one said this was also a bankruptcy question. Post-bankruptcy, he said, I have a creditor that keeps saying I owe money. It keeps putting it back on my credit report after bankruptcy. I keep disputing it and provide bankruptcy documents, but it keeps coming back. Here's what I had to say to that. We should all be so lucky as to what's going on right here. Because if this was a creditor that was listed on your bankruptcy documents, you've gone through the bankruptcy process, you've received a bankruptcy discharge, and they're still doing this, they're still putting it on your credit report, they're still reaching out to you saying you owe it, and you provided them notice of the bank, you need to go to your bankruptcy attorney. Go to the person who helped you file the bankruptcy case. And this is lawsuit time. They are violating the bankruptcy court's discharge order. The discharge order is a court order from a federal judge, and they're completely thumbing their nose at this judge. The court will not only make them stop contacting you, they'll make them take it off your credit report. They're going to put some money in your pocket. They're going to sanction this creditor and require them to write you a check. Depending on what part of the country you're in, it could be a pretty good check. You could, depending on what else has been going on here, how many times you told them to stop, how many times you provided them information. They may just, I could see $5,000-$6,000 in your pocket, pay for your attorney's fees, everything else to get this dealt with. So, all right, let's see here. Oh, we had a follow-up here with Carpe Diem. Said the Virginia case was filed in 2023 with a hearing in May of 2024. That I defended using your advice, citing hearsay. Before the next hearing came through, they filed the non-suit. They have now sent a new debt validation letter, which I responded to in the negative. I will wait to hear what's next. Yeah, you go ahead and bring that back bring that back here to the live stream. We can talk about that as you get some additional information. All right, looks like Hercules also had a follow-up. Said the statute of limitations on my debt ends in January 9th. 2025, how can I delay a lawsuit until then? The collector's response to my validation request had gaps, no signed agreement, incomplete history. What strategies can I use to complicate their case? So, as far as if the statute of limitations ends in January, we're what, three months away from there. Validation, they're going to wait 30 days. They're not going to be able to proceed if you do a validation letter. Disputing it like that will likely do that. If it's close, it's going to be tough. Sometimes your creditors, they're aware typically of the deadline for the statute of limitations, and they're going to come in and file that. So you may not be able to, other than asking for them to validate it, then by law under the FDCPA, they're going to have to wait that 30 days, and they can't do any additional collections until they comply with that. So you may want to take a look at that and see what can get squared away from there. So, All right. I think that will do it for today. Again, please go check out SoloSuit. Go check out some of the products they offer. They do a great job at helping to support the channel, keeping us going here. If you have any additional questions, go ahead and throw them in the comment section. And with that, we'll catch you next week.